Welcome to The Fine Print, the podcast where we explore the law, its impact, and the people who shape it. I'm your host, Riddell, and on today's episode, I'm thrilled to welcome Ms.Abirami Subramanian, a lawyer with experience practicing across two jurisdictions and in two distinct fields, criminal law in Australia and shipping law. Having navigated both the intensity of the courtroom and the complexities of commercial disputes, Ms. Subramanian brings a refreshing perspective on what it means to practice in these two very different areas of law. So, to start us off, what initially drew you into specializing in criminal and shipping law?
Hi, Rudel. Thanks a lot for inviting me onto your podcast. I really appreciate it. It's great to be here. As far as what drew me to specializing in criminal law, I think as a start, first of all, as a student, I was very interested and passionate about human rights and social justice. And so, for example, when I was in university, I was engaged in the Make Poverty History and Fair Trade campaigns on campus at Monash Uni in Melbourne. And I was also part of a group of students who founded a refugee advocacy group. So naturally, after I graduated from uni, I was kind of drawn to careers that had a public interest or a social justice element. And after I completed my graduate diploma in legal practice, and that was in ANU in Canberra, I had a friend who was working at the legal aid office in regional Victoria, and she suggested that I apply for the generalist lawyer position there. And the generalist lawyer position is really about 90% criminal law with some community law aspects, such as maybe child protection law. So, anyway, I applied for the position and I got it. And it was a great experience. So, I worked under a senior criminal lawyer who was an amazing mentor and who gave us junior lawyers really priceless insights into how the law works on the ground on a day to day basis. And the thing I loved about the job at Legal Aid was that even at that junior level, we were given a level of independence and autonomy that you usually don't have available to you as a junior associate. So that was fantastic. And the other thing that I really enjoyed was that I was in court at least 2 to 3 weeks, doing advocacy, so such as bail applications, pleas in mitigation, and duty lawyering work. And I really enjoyed that because for me, the advocacy aspect of practicing law is something that I really love. As far as shipping law goes, I really fell into it by accident. After a couple of stints doing general civil and commercial litigation in law firms in Singapore, I applied to this firm, which happened to have a strong focus on shipping matters and disputes. And it was really a steep learning curve for me because we had an arbitration matter that was going up for hearing in about 2 months. And I had to get on top of not only the facts and documentary evidence, but also key legal concepts and instruments which are unique to shipping law, such as demurrage, contracts of freightment, and so on. And it was a great experience for me because I also had the opportunity to appear as second chair in the arbitration, and I had the opportunity to cross-examine the opposing party's expert witness. And at the end of the arbitration proceedings, after the close of oral submissions, the presiding arbitrator was kind enough to tell me that I had done a good job. And that was really something that had an impact on me because as a junior lawyer, when someone says something like that to you, it's such a boost of confidence and you kind of feel, okay, maybe I can be a decent lawyer after all, despite all this self-doubt that you may have.
Thank you for, giving us a window into your career and how your career in law grew from an early passion for protecting human rights combined with the path that, unexpectedly led you into shipping law, where you gained so much experience. So, having worked in both these areas, how would you now define justice?
So I think to me, justice is really the opportunity to have your case heard, whether it's a civil matter or a criminal matter. And when you talk about the opportunity to have your case heard, I think that in turn has three aspects to me. So the first aspect I would say is really having access to justice. So that is the ability to access legal representation regardless of your financial situation. I think the second aspect then about the opportunity to be heard is really to have legal counsel to represent you who are actually competent and dedicated to putting your best arguments and your best case forward. And you would have to have counsel or you would need counsel who would put forward your case the same way that you would yourself if you had the skills as a lawyer. And I think the third aspect for me of justice or the opportunity to be heard is really having the opportunity to have your case heard in the context of a legal judicial system that provides both procedural and substantive justice. So by that, I would mean, a legal system that ensures that a party is allowed to make use of the procedural mechanisms that are available, such as the adduction of relevant and important evidence, proper disclosure of evidence from the opposing party, and so on. And then, of course, you also have the substantive justice aspect, which is having courts with a competent judiciary who will hear your case impartially in accordance with not just the letter, but also the spirit of the law, and ultimately render a decision that is not only rational and based on the objective evidence, but also tempered by compassion where that's appropriate.
That's such a clear way of putting it. Your 3-point response, having access to justice in the first place, alongside with the legal counsel to represent you, and finally having a legal judicial system that provides both procedural and substantive justice, truly encapsulates the idea of justice as a whole. So, adding on to your journey and experiences, what are some of the biggest ethical dilemmas that you faced in your practice?
Okay, so that's a really good question. So to be honest, from my memory, I haven't really experienced any major ethical dilemmas. But one thing that I have encountered as a junior lawyer, which gave me some grief, I think, was that once in a while you happen to work for a senior lawyer who might conduct a client's case in a way which to you does not appear necessarily to be in the best interest of the client. And sometimes it appears that, or it seems as though that senior lawyer is really conducting the case in a way that suits their best interest. And of course, as a junior lawyer, because of your position and the fact that you report to the senior lawyer, your ability to intervene is going to be limited. So you can't really provide advice to the client or run the case in a way that's contrary to the position that your partner has taken, especially when technically it's really their client and you're just an associate lawyer. And of course, on top of that, you have also that, that niggling sense that, well, maybe your judgment of what is correct or in the client's best interest might not be necessarily be correct because of your own lack of experience. But I think, I've tended to listen to my gut feeling and where I've instinctively felt that things are not quite right and I've encountered such conduct, then my chosen course of action has really been to leave that place of work and to look for an environment which, is a better ethical and moral fit for me. So I think, in that vein, one thing that I would, suggest to aspiring law students or lawyers is really, pay attention when you're doing your legal studies, not just to substantive legal concepts, but also to ethical principles. Because at the end of the day, your duty is to act in the client's best interests. And of course, this is subject to your overriding duty to the legal system itself. And besides this, to act ethically is not only something that you owe to your clients and the legal system, but also to yourself. Because as a lawyer, whether or not you report to someone senior, you ultimately bear responsibility for your conduct as a lawyer and how you run your case. And finally, you also have to remember that in this profession, the legal profession, your reputation and credibility are perhaps, your most important assets that you would have. So for example, you might have a client come to you once and perhaps, you don't really run the case in a way that's really in their best interest. Perhaps you drag it out, because you want to get more fees and that sort of thing. But at the end of the day, eventually someone's going to look through you or you're going to end up with a reputation and clients are not going to come back to you. So, you really want to make sure that you run your practice in a way that's ethical.
That's so true. Acting in a way that's ethical and especially acting in the client's best interest may be hard, especially as a junior lawyer with, limited ability to intervene. and having that sense of ethics be a part of the job and the legal system as a whole, not just something that you owe to your client. So, on a related note, focusing in on criminal law, what are some misconceptions people have about criminal lawyers?
I think for criminal lawyers, the question that most lay people would have for a criminal lawyer is, well, how can you represent or defend someone who's guilty and sometimes, of a horrible crime? I think part of the answer is that there's a misconception that criminal lawyers are going to, sort of fight every case that comes to them. And that's actually far from the case. Because most of the times, I'd say at least 80 or even closer to 90% of cases will end up in a plea of guilty rather than the client defending the charges outright. There might be some negotiation and back and forth between the prosecution and the defense, but eventually probably resolves in a plea of guilty to at least some of the charges or to modified charges. And when your client pleads guilty, your role is really to put forward all the mitigating circumstances of your client's situation. So let's say, for example, perhaps they were in a very bad situation when they committed that act of theft, or they were provoked by the victim before they threw a punch late at night in a bar. And so your job is really to assist the court in coming to the fair sentence, not necessarily a harsh sentence or a lenient sentence, but one that is proportionate and fair to your client, proportionate to the offense and fair to your client. So really, the impression that you're helping people to get off scot-free is not accurate. You're actually just trying to make sure that they get a fair sentence. Of course, besides pleas of guilty, there are going to be cases where you will advise the client to defend the charges. So, for example, where your client actually has a legitimate defense or where the prosecution's evidence doesn't stack up to that standard of beyond reasonable doubt that's required under the criminal law. And, in such cases, our legal system actually expects you to put forward your client's best case for why they should not be found guilty. And the prosecution, on the other hand, has to put forward its best case as to why your client should be found guilty. And, we call this the adversarial system of justice, which is premised on the idea that when both parties put their opposing cases to the court, then the court is in the best position to come to a fair and correct decision. But ultimately, that question of guilt is decided by the court. And so, as a lawyer, it's not your place to decide if your client is guilty or not. That's really for the court. And we also have to understand that there are situations where an innocent person can be charged. And in such cases, criminal lawyers have the duty to do their best to ensure that a person is acquitted. So ultimately, the criminal justice system has safeguards against the risk of an innocent person being found guilty, and the right of access to a defense lawyer and the standard of proof beyond reasonable doubt are some of the safeguards that the system has to guard against the conviction of an innocent person. And criminal defense lawyers form an important part of the safeguards that the system has.
I hadn't really considered that perspective that, lawyers aren't there to decide guilt, but to help the court reach a fair outcome. It really highlights how important their role is in balancing the system and making sure every case is properly represented, even those accused of serious crimes, that they still have their circumstances fairly considered. So, with that in mind, what reforms do you think are most urgently needed in the criminal justice system today?
So, I think for me, because I come from the perspective of a defense lawyer, the more obvious issues that I see are more to do with the defense side of things. So I think one of the key concerns in criminal defense is whether the accused has access to quality legal representation. And I think this is an area that needs significant reform and definitely more funding in most jurisdictions around the world. So, for example, you have the UK, which is now facing a crisis in that criminal barristers are barely being paid a living wage for legal aid work due to a proper lack of funding. And this is inevitably going to result in less people wanting to be criminal barristers and less quality representation being available to accused. And that in turn is going to lead to poorer outcomes in terms of criminal justice and criminal jurisprudence. So I think that's something that really needs addressing. In Singapore, we have recently instituted the Public Defender's Office, which provides criminal legal aid. And I think this is definitely a step in the right direction. And to my understanding, there's a merits test and there's a means test, which applicants have to satisfy before they qualify for aid. And that's to be expected. I have to say that since my experience in criminal law in Singapore is quite limited, I can't really say how effective the PDO has been in ensuring access to legal aid for deserving applicants, including, for example, juvenile accused and those with intellectual disabilities or mental illness. But as I said, it's definitely a positive development and a step in the right direction. The other key concern for me is that the criminal justice system, in my opinion, still has an insufficient focus on rehabilitative justice, especially when it comes to sentencing. So while there's been movement towards the rehabilitative justice model, deterrence and especially general deterrence still remains a significant underlying motive for sentencing in many jurisdictions, including Singapore. So, for example, in Singapore, you have the death penalty for drug trafficking. And the rationale behind imposing the death penalty is that it deters others from committing the same crime and therefore stems the flow of illicit drugs into the country and avoids, the disastrous consequences that come from drug addiction. But, we have the Ministry of Home Affairs in Singapore, and the Ministry of Home Affairs has conducted studies to support the government's stance that the death penalty acts as a deterrent. But at the same time, there's been criticism of these studies, and commentators have said that there's no evidence that the same deterrent effect could not be achieved by a more humane, but also a severe sentence, such as life imprisonment. So the question is, should we really be doing studies to see if there are alternative sentences can have the equal deterrent effect that the death penalty is alleged to have? And, when it comes to the death penalty, my concern is that sometimes you have a person with an intellectual disability, such as Nagendran Dharmalingam, who was sentenced and accused for drug trafficking in 2022. And when you have a person who's more vulnerable and unique from the general population, in that they have an intellectual disability or a mental illness, for example, then I think the argument for general deterrence justifying such a harsh punishment as the death penalty is much less persuasive, especially if that person's disability can be said to be a factor that contributed to the offending. So these are the two key areas that I think need reform where the criminal justice system is concerned in a general sense.
I really appreciate that viewpoint, especially how access to proper legal representation and a focus on rehabilitative justice are crucial for a fair system, touching upon the death penalty in Singapore and the crimes surrounding that, and especially concerning vulnerable groups. So, to dive a bit further, what moments in your career have reaffirmed your belief in the importance of criminal justice work?
I think there are times, in criminal law practice when you have a client who's from a vulnerable background or who's experiencing significant difficulties in their personal circumstances. And in those cases, when you're able to really tell that person's story to the judge and obtain a sentencing outcome that's fair and that allows that person to have a second chance at building a positive life, that's deeply reaffirming and also deeply emotionally fulfilling. And then on the other hand, you have cases, like I mentioned before, where you have a client who has been charged with an offense where the evidence against them is, at least in your opinion, not up to the standard required to convict. And if in those situations, when you're able to secure an acquittal, that's also deeply satisfying because it reaffirms your faith in the adversarial system of justice. And of course, beyond legal outcomes, there's also just simply the immense satisfaction that you can get from feeling that you've helped someone navigate a very intimidating and stressful period of their lives.
I can imagine that having that emotionally fulfilling moment really makes the job feel worthy and the feeling of satisfaction from truly making a difference in someone's life. So, shifting focus, How different is life as a shipping lawyer compared to a more conventional corporate or litigation work?
So, the thing about shipping law is that it is an area of law which has both great breadth and great depth. So it's got very unique concepts such as, the admiralty jurisdiction of the courts, the right to arrest a vessel, and you've got unique documents such as bills of lading, letters of indemnity, charter parties, etc., which have special legal significance and have, a significant body of jurisprudence just built around those concepts and those documents. So when we talk about the admiralty jurisdiction, it's interesting because the admiralty jurisdiction of the courts allows a party who has a maritime claim to bring an action in rem, as we call it, which is really the arrest action, against the vessel to which the maritime claim relates. And the primary purpose of arresting a vessel is to make sure that it remains within the waters of the jurisdiction, so that in the event that your maritime claim is successful, then you can apply for an order to sell the vessel and use the proceeds to satisfy the claim that you have. So the arrest of a vessel is, very unique to maritime law, and to me something that's quite exciting. And it's also very time sensitive. You often have a very short time in which to prepare and bring the arrest application to court, because you don't want the vessel to leave the territorial waters of the jurisdiction before you make the application and obtain your arrest order. And the arrest application is also one that is known as ex parte, which means that it is made without informing the other party, who is usually the owner of the vessel. And the reason for this is that if you notify the owner of the vessel of the arrest application, then there's a risk that obviously the vessel is going to leave the territorial waters because it doesn't want to be arrested. And if that happens before you obtain your arrest order, then what happens is that you've lost your security, which is the vessel. And that's a situation that you want to avoid. So that's the underlying reason for why arrest applications are ex parte. However, in ex parte applications, you do have a duty of full and frank disclosure, where you have to disclose to the court any matter that might be relevant to the application, and even if it is potentially adverse to your client's case. So, for example, in a recent arrest matter that I was involved in, we had to disclose to the court, certain circumstances that were potentially relevant to the question of whether the client even had the right, or what is known as the legal standing, to bring the arrest application. Now, ultimately, we got the arrest order from the court, but what was important that we had to put the matter before the court so that the court could make a fair and informed decision. The other thing about arrest applications is that as a shipping lawyer, you have to be really careful when bringing these applications. If it's found later that your client's arrest application was made in bad faith or with gross negligence, then your client can be liable for wrongful arrest and have to pay the other party damages for losses that have been caused by the wrongful arrest of the vessel. So it really is a matter that requires a great deal of expertise, and you really have to be careful how you tread when you're making an arrest application. And the other interesting aspect, I think, of shipping or international trade matters is that, almost inevitably, they will have an international aspect, since the subject matter, which is shipping, is something that takes place across borders. So you often have parties from different jurisdictions involved in a single case. So, for example, the owner of the goods being shipped could be from one country, and the shipping company that has been put in charge of shipping the goods could be from another country. And the owner of the vessel that has been chartered for the voyage could be from yet another country. And besides this, so not only do you have parties from various jurisdictions, you can also have multiple suits or sets of proceedings being commenced in various jurisdictions arising out of the same event. So, for example, in one of the matters I was involved, we represented the owners of a vessel that was involved in a collision with another vessel, and that collision ultimately led to a significant loss of cargo. And so the suit that was brought in Singapore had actually been triggered by a suit in the United States. And the defendants in the US had brought a suit against the shipping company, which was based in Singapore. And that shipping company, in turn, brought our clients in as a third party to the Singapore proceedings. And their argument was essentially that really it was our clients as the owners of the vessel who were responsible because we had not exercised due diligence with relation to certain obligations that we owed in terms of the vessel. So apart from these two sets of proceedings, you also had a concurrent arbitration taking place in the UK. So if you're interested in work that has a cross-border or an international element, then shipping work definitely is going to provide that opportunity. And there's also the opportunity for being involved in, international arbitration matters. And that's really fantastic because international arbitration allows you to be exposed to arbitrators and lawyers, even from different jurisdictions. And it's really interesting to observe the different approaches to legal analysis and advocacy.
That's such a clear explanation of the differences between shipping law and other types of law. Having arrest applications be quite prevalent in your kind of response, as well as having this internationally connected aspect of shipping law, all ties into how specialized and fast paced shipping law is overall. So it must be quite complex to navigate cases that span multiple jurisdictions and involve so many moving parts. Adding on to that, how have you seen maritime law evolve over time?
Okay, so frankly speaking, I haven't been practicing shipping law long enough to say that I've seen it evolve per se. But what I can say is that maritime law is one of the most ancient areas of law, and it probably has been around in some form or other for as long as humans have been engaging in trade relations. And while maritime law does evolve from time to time, there are also recent instances where the courts reaffirm long standing principles, such as, for example, the sanctity of the Bill of Lading, commonly known as the BL, as a document of title and the possessory rights of the lawful holder of a bill of lading to the goods that are being shipped. As far as technology goes, I think one significant technological development is the advent of the electronic bill of lading, which is based on blockchain technology. And this promises more secure transactions and less risk of fraudulent trades being made or unauthentic bills of lading being circulated within the system. And hopefully, we hope that this will result in a reduction in disputes as to who is, for example, the rightful holder of the bill of lading and is therefore entitled to possession of the goods being shipped, where you have such fraudulent conduct being taking place.
That's a really insightful point, and it's fascinating to see how an ancient area of law, like maritime law, is adapting to modern technology, like electronic bills of lading, to make trade more secure and to reduce disputes. So, similarly, how does globalization change the landscape for maritime law?
So that's a great question, especially in today's world. So shipping and international trade are, I think naturally dependent on globalization. And the equation also moves both ways in that, the more cost effective and efficient shipping practices are, then that benefits international trade as well. So the maritime industry in particular is very sensitive to any disruptions or significant changes in globalization trends. And now, what we have recently is a general trend towards more protectionist policies globally, and particularly with the US government now imposing significant tariffs on products from various nations. And this is ultimately going to lead to increased operating costs, reduced consumer demand, and potentially even you may have shipping companies rerouting their shipments in an effort to avoid tariffs. So, what you have is that these disruptions may lead to a party who is involved in a shipping transaction or a chartering arrangement being unable to fulfill their contractual obligations towards the other party. So, for example, let's say you have a China based company that's supplying steel to the US market. And this supplier has entered into a 5-year contract of affreightment with a ship owner where it undertakes to the ship owner that we will provide you with a certain tonnage of steel to be shipped by the ship every year. And of course, the charter hire that the ship is going to earn is going to be based on that tonnage requirement being fulfilled. So then what might happen is that with the current US tariffs on steel imported from China, the steel supplier may find that it's actually unable to fulfill its commitment to provide a certain tonnage of steel to be shipped by the ship owner. And that would result in the ship owner earning less in charter from the supplier. And this could very likely lead to disputes between the parties, where the steel supplier may argue that the tariffs actually constitute a force majeure event that excuses it from fulfilling its contractual obligations. Or it may more generally argue that the contract has been what we call frustrated, such that it's impossible for the supplier to perform its obligations under the contract of affreightment. Now, the thing to keep in mind, however, is that such defenses would have to be carefully considered, as these defenses are not easy to establish, and there's a high threshold to be met before you can prove them. But overall, the point I'm making is that we can probably anticipate such disputes arising between parties as an effect of increased tariffs.
It's fascinating to view how globalization affects law, notably how shifts in trade policies and tariffs can create complex contractual disputes across borders. So, following that thought, how does the growth of sustainability measures affect shipping law?
So, this is, of course, again, a very pertinent question for our times. The shipping industry is known to be a major polluter, since shipping emissions are a major source of carbon dioxide and other greenhouse gases. And, traditionally, the shipping industry has known to be somewhat of a slow mover when it comes to adopting environmental sustainability measures. However, we do have the International Maritime Organization, or the IMO, which has, for example, come up with a global net zero framework, which it intends to implement. And, while the formal adoption of the framework is yet to take place, what it does envision is the implementation of measures such as a global fuel standard and an emissions pricing system that disincentivizes the production of greenhouse gas emissions. So, moving forward, shipping companies and ship owners will have to consider the adoption of measures to comply with the framework, such as the adoption of alternative fuels with lower emissions, for example. Now, of course, apart from the broader public regulatory perspective, there's likely to be a trickle down effect in private contracts between parties involved in the shipping industry. So, for example, you have Professor Stephen Gervin, who's a highly esteemed academic in the area of maritime law. And he's written a new textbook which examines how new standard clauses are being introduced into charter parties and bills of lading, which are aimed towards facilitating carbon reductions. And the book also examines how these standard clauses could potentially transform traditional shipping contracts into more collaborative contracts.
I love how you broke that down, and it's compelling to see how environmental sustainability is starting to reshape not just regulations, but also the way shipping contracts are structured and negotiated. Finally, what is some advice you would like to give to aspiring law students wanting to pursue a career in these fields of law?
So I think if you're an aspiring law student, I think the first thing to do if you are interested in a particular area of practice would be to secure an internship in a legal practice that specializes in that area. So that way you really get to see how practice in that area of law pans out on the ground on a day-to-day basis. And for maritime law, since this is usually not a core subject in a law degree, what you could do is choose to study the elective maritime law subjects, such as admiralty law and international trade law, that are usually offered in most universities. Where criminal law is concerned, I think a good place, for example, to intern would be criminal aid agencies in whichever jurisdiction that you're interested in practicing, because these are going to give you an intense exposure to criminal law practice. At least that was my experience when I was at Victoria Legal Aid in Australia. So, for example, in Singapore, what you might do is you might try to apply for an internship at the Public Defender's Office if you're interested in the defense side of things. And if you're interested in the prosecution side of things, you could try and secure an internship in the Attorney General's chambers, which is responsible for the prosecution of offenses. I'm not sure what the procedure is for internship applications are at, say, the AGC or the PDO, But I think, if you're based in Singapore, you can always reach out to them to find out more. And I think for criminal law, at least, one important thing is to probably have an interest in social justice. And that applies whichever side of the fence you're on. So whether you're on the criminal defense side or you're interested in prosecution work, because ultimately the aim of both criminal defense and criminal prosecution work is, as a whole, if you take a holistic approach, is to ensure socially just outcomes, both for the community and for the individual accused person.
Those are some great pieces of advice, and it really shows how important hands-on experience and, targeted electives are for building a career in specialized areas like maritime or criminal law, as well as, of course, having the passion for it, as you mentioned, with the social justice kind of element. So thank you so much for your time, Ms. Subramanian. And to all my listeners, court is now adjourned until next time with the fine print.